Hello everybody, welcome to ixamBee. This is Amrita and I am here before you all with the last video of the MCQ series that we have started for Sebi Grade A Legal Officer Examination. This series we have started a few days back and this is part 4 of that particular video series. In this I am going to conclude with the last 30 set of questions out of the 100 most important questions that we are discussing for Sebi Grade A Legal Officer Examination. But before we proceed, I would like to remind you, don't forget to subscribe to our YouTube channel of ixamBee and stay updated with such kind of beneficial videos for Sebi, not only for Sebi but also for other government exam preparations. We provide coaching exclusively at ixamBee. You can visit our website for details for relating to all the courses available. You can also call on the number that is provided over here and you can write to us at hello@ixambee.com. We have started the 100 most important question series and question number 71 to 100 I am going to discuss in this video today. This is very important from exam point of view and friends ये exercise आपके लिए इसलिए भी helpful है, जैसे मैंने हर वीडियो में भी कहा है कि आपके लिए ये रिविजन पॉइंट ऑफ व्यू से बहुत ही अच्छी एक्सरसाइज है. 20th Feb को आपका एग्जामिनेशन है. This will be a very good revision practice and you will understand what kind and pattern of questions can be asked. So do take benefit of such kind of videos. अगर आप लोगों ने पहले 3 पार्ट्स नहीं देखे हैं तो आप वो भी देखिए और ये भी देखिए. हम लोगों ने सब्जेक्ट वाइज एज पर द वेटेज ये क्वेश्चंस एक्सक्लूसिवली सेबी ग्रेड लीगल ऑफिसर एग्जामिनेशन के लिए कार्व आउट किए हैं, जो मैं इस वीडियो में डिस्कस करने वाली हूँ आपके साथ. नाउ स्टार्टिंग विद द 71st question. In calculating fractions of terms of punishment, the imprisonment for life is considered equal to imprisonment for 10 years, 14 years, 18 years, 20 years, 30 years. Now, yes, this question actually bit twisted, but it is easy only. If you are having good knowledge of the subject, then you can easily answer it. And the answer is D. 20 years. 20 years fraction is calculated for the purpose of imprisonment of life. You can consider imprisonment of life equivalent to 20 years fraction of punishment. Section 57 of IPC deals with the fractions of terms of punishment. In calculating fractions of terms of punishment, imprisonment for life will be equivalent to 20 years. This is directly mentioned in the section. Question number 72. Classification of compoundable and non-compoundable offences is provided under first schedule of CrPC, second schedule, section 320 of CrPC, 321 of CrPC, 178 of CrPC. Yes, this is a direct question, but compoundable and non-compoundable offences बहुत basic area है CrPC का, तो आपको पता होना चाहिए. And the answer is C, that is section 320 of CrPC. प्लेस ऑफ इंक्वायरी, ट्रायल, ये सारे सेक्शंस मैंने एक्चुअली ये पीपीटी भी अटैच है वीडियो के साथ डिस्क्रिप्शन में. आप आपके रेफरेंस के लिए ये सारे एक्सप्लेनेशंस देख सकते हो. इट कैन बी अ गुड रिविजन ऑल्सो फॉर यू एंड यू कैन बी वेरी क्लियर with what provisions deals with what that were included in the options. All these are important only, that's why we have included it in the options so that you can side by side revise these provisions also. Next question, question number 73. For maximum how long in a whole a convicted person can be kept in solitary confinement? Solitary confinement से related provision directly provide गया है IPC में. And कितने time तक maximum आप एक person को solitary confinement में रख सकते हो? And the options you can see. And here you have to note down such kind of questions you have to be very clear with. यहाँ पे इन अ होल पूछा है. इन अ होल मीन्स ओवरऑल. अगर वो कंटिन्यूटी में पूछते तो आंसर कुछ और रहता, बट नाउ इन अ होल है, दैट मीन्स वी हैव टू गो इट ओवरऑल पनिशमेंट के टेन्योर में. द आंसर इज बी एंड दैट इज ओवरऑल यू कैन ओनली कीप 3 months not exceeding 3 months in the whole. It is specifically provided in section 73 of IPC. and अगर आपको एक ये 3 months भी जो आपको रखना होगा solitary confinement में, that also you have to divide in that also you have to actually divide for the purpose of time being when you are keeping it in continuity. अगर आप continuity में रख रहे हो तो फिर आप at a time 14 days के ऊपर नहीं रख सकते. एंड ओवरऑल अगर आप पनिशमेंट का देखोगे तो टेन्योर में से मैक्सिमम आप 3 months की पनिशमेंट दे सकते हो. सेक्शन 73 IPC का आप रीड कर लेना फॉर दिस पर्पस. नेक्स्ट क्वेश्चन 74. A, an officer of a court of justice, being ordered by that court to arrest Y, and after due inquiry believing Z to be Y, arrests Z, then A is guilty of what? In such kind of a situation, ऐसे सिचुएशन बेस्ड क्वेश्चंस भी पूछे जाते हैं कभी कभी, स्पेशली IPC में से बहुत बार क्रिमिनल लॉ में से पूछे जाते हैं. एंड द आंसर इज गोइंग टू बी B, that is no offense. He has not committed any kind of offense over here because he is not doing it intentionally. He is doing it as a part of his duty, and that too this is picked from the illustration under section 76, which is a defense that has been taken from IPC. This was an illustration. Point number B, which was picked directly from section 76. 75. Duly incapax in criminal law describes the liability of very important part and expected question. Options are insane person, child below 7 years, 12 years, person under influence of drugs, person under the influence of intoxicants. Duly incapax. Yes, actually this is an easy question. Answer is B, child below the 7 years of age is known as duly incapax. It is a Latin term. ये explanation है, पूरी तरीके से describe कर रहा है, and child below 7 years of age is getting a defense under the general exceptions. Refer section 82 of IPC also relating to this. Question number 76. The right of private defense of body is not available against a sound person, not available against a child, available against any person, available to all irrespective of age and capacity. Now these are some statements available only to adults. Now these are some statements, and इन statements के basis पे आपको options दिए गए हैं. ऐसे भी questions कई बार पूछे जाते हैं and आपको बहुत कीनली ये क्वेश्चंस को सॉल्व करना होता है, क्योंकि कई बार आप कंफ्यूज हो जाते हो स्टेटमेंट्स और ऑप्शंस में. वो नहीं होना चाहिए. सो राइट ऑफ प्राइवेट डिफेंस ऑफ अ बॉडी इज अवेलेबल. These statements and these options, you have to pick the correct option. Which combination of statements is correct? That is given in these options. It is relating to private defense. Private defense is another important topic from Indian Penal Code. And the answer is B, that is statement 3 and 4. Statement 3 available against any person. Statement 4 available to all irrespective of age and capacity. It is available to all. Every person can avail it. Section 97, right of private defense of the body and of property. Every person has a right subject to restrictions that are contained in section 99. So you can go through this section as well as go through section 99 to know the limitations on right to private defense. कभी कभी limitation से भी question आ जाता है. The offense of abetment is committed by. वेरी इजी क्वेश्चन. लॉजिकली आप इसको सॉल्व कर सकते हो, एंड अगर आपको डेफिनेशन पता है तो आप विद इन सेकेंड्स सॉल्व कर सकते हो. एंड द आंसर इज ई. ऑल ऑफ दीज आर द एलिमेंट्स ऑफ द ऑफेंस ऑफ अबेटमेंट. Ingredients, section 107 of IPC, you can refer, it defines abetment, and all these terms that we have used in the options are actually the ingredients of abetment only. Question number 78. A instigates B to murder C. B is stabbed, but B stabbed C, but C recovers from the wound. What will be the result? C has recovered anyhow. तो ऐसे situation में क्या होगा? What will be the conclusion? A is guilty of abetment or to commit murder, abetment to commit grievous hurt, guilty of attempt to murder, not guilty as desired result is not obtained. None of the above. This is also a very simple logic based question again, and the answer is A, because A is guilty of abetment to commit murder. He has recovered from the wound, that is his luck, his fortune, but A का intention था to instigate B ताकि वो सी का मर्डर करे। तो ए का पनिशमेंट यहाँ पे पूछा गया है, बी का नहीं पूछा गया है। अगर बी का पूछा जाता तो इट वुड हैव बीन depending on the severity of his wound, it can be attempt to commit murder also and attempt to commit grievous hurt. But यहाँ पे A का पूछा गया है, so A is guilty of abetting B to murder C. Correct option is A. Section 108 of IPC deals with the abettor and also describes what is the situation. और ये question भी illustration से pick किया गया है, you can refer this. Question number 79. A warrant of arrest is a command that must be in written order, signed, sealed and issued by a magistrate, addressed to the police officer, both A and C, or all A, B and C. So this is a technical question. Warrant of arrest is what? It is a command and it should be in what form? That is covered here. All A, B and C is the correct option. These must be the contents of that particular arrest warrant, and that is form of warrant of arrest and duration that is covered under section 70 of CrPC. Procedural question है, and 72 provides to whom it should be addressed or directed. Question number 80. When a person with the intention to cause damage to other person causes destruction of the property, then he is said to have committed mischief, rioting, robbery, nuisance, theft, offences against property. Concepts should be clear, then you can easily answer this question, and the answer is A, mischief, because this is offences relating to property directly, and theft तो ये नहीं हो सकता, बाकी के तो कोई offences है नहीं. Mischief is the only correct possible answer over here. Section 425 of IPC defines mischief. Meeting of minds is an essential element of this offence. Yes, meeting of minds is an essential element of this offence. अब यहाँ पे आपको offence का नाम नहीं दिया है, but sections दिए गए हैं. You have to be very clear with such very basic offences at least, and their definitions and section numbers. ऐसे अगर कोई क्वेश्चन आता है आप मिनटों में सॉल्व कर सकते हो. ऑफ कोर्स 120A क्रिमिनल कॉन्स्पिरेसी की बात की जा रही है यहाँ पे, which has the very main ingredient to be meeting of minds. Let's go on with the next question. For criminal conspiracy, there must be an agreement between at least 2 persons, 3 persons, 5 persons, 7 persons, 9 persons. Criminal conspiracy के लिए there must be an agreement between. अब यहाँ पे at least पूछा गया है. At least there must be 2 persons. This is also very easy question. A option is the correct option. 120A of IPC you can directly refer. Now from CPC, precepts are issued under section 46 of CPC. For what purpose? Serving summons on persons residing beyond local jurisdiction, serving a warrant on the JD, judgment debtor, attaching the property of JD, issuing commission for examination of witness, none of the above. Yes, precepts का concept भी unique है CPC में से 46. यहाँ पे आपको section number भी पूछा जा सकता है, precept क्या होता है वो भी पूछा जा सकता है. ऐसे कुछ जो हटके प्रोविजंस होते हैं इनसे भी आपको अवेयर रहना है अगर एग्जाम में आए तो. एंड द आंसर इज सी, अटैचिंग द प्रॉपर्टी ऑफ जजमेंट डेप्टर. सेक्शन 46 यू कैन रेफर ओवर हियर फॉर दैट पर्पस. अटैचमेंट ऑफ प्रॉपर्टी फॉर द दैट इज बिलोंगिंग टू जेडी is specified in the precept, and actual purpose of precept is to secure that. Question number 84. Admission according to the Indian Evidence Act includes statements that are made by. Admissions, very important topic from Indian Evidence Act. Very thoroughly you should prepare it from that. And out of these options, what is admission according to Indian Evidence Act? It includes what? Statements made by persons expressly who are referred to, authorized agents of parties, persons whose liability has to be proved, persons from whom the parties derive their interest in the subject matter, all of the above. Yes, the answer will be E, all of the above, as all of the above options are correct, and they include statements that are that an admission can provide for. For this purpose, you can specifically refer section 17 also for the definition, and 18, 19 and 20 for the specifications. Question number 85. Every summons that is issued by a court under CrPC What shall be the form and contents? Again, it is a technical question. Procedural one. Easily you can answer this. Actually, if you are just having practical knowledge also, you can easily answer. Under CrPC, when the summons is issued, that shall have what kind of contents? These options, it should be writing in duplicate, bear the seal of the court, shall be signed by the presiding officer. It shall be in writing, signed by presiding officer, and shall bear the seal of the court. You have seen the options are very easy, just words have been changed somehow. And if you read the question carefully, you can easily answer. C option is the correct one, including all the necessary requirements. Section 61 of CrPC, you can refer for that purpose, as it provides the form of summons. 86. A meets D on a high road, shows him a revolver and demands D's purse. D in consequence surrenders his purse. The offence that is committed by A is... Yes, this is again a very important and a very easy question. You can immediately answer it within 30 seconds because this is relating to the very basic offences of IPC. If you are clear with that, you can easily answer this. That C has committed what? C has committed the offence of robbery. This illustration has been directly picked as it is from the section. You can refer section 390 for this purpose, and you can understand, and you can actually answer it very easily. How many minimum persons are needed to call robbery or a dacoity? Minimum number of persons for robbery. Differentiation between robbery and dacoity, actually this is a very basic difference, and the minimum number of persons shall be 5. If there are 5 or more than 5 people committing a robbery together, then they will be said to be committing dacoity. This is also directly provided under section 391 of IPC, defining dacoity. 5 or more persons shall conjointly commit a robbery. 88. Maintenance under section 125 of CrPC cannot be claimed by. Very important provision from CrPC, very much availed under matrimonial disputes. And who cannot claim maintenance under 125 of CrPC? This is mentioned in the section. Directly married daughter who has attained majority and she is married also, so she cannot claim maintenance. This is specifically provided under CrPC, and you can easily answer this question. Under section 102 of CrPC, who is authorized to seize the stolen property? Police officer, judicial magistrate, executive magistrate, special magistrate, district judge. To seize the stolen property, who is authorized? Very easy. Don't even need to know the provision for this. Obviously, not the magistrate and the judges, but the police officer is going to be handy with the stolen property and seize it. The judges in our adversarial system of judiciary in India, the judges do not go and investigate the matters, so they cannot seize the property. And the provision also is provided, section 102 of CrPC. Any court may alter or add to any charge any time before. Charge, another important subject from CrPC. When can a court alter charge? There is a section direct for this purpose, alteration of charge, and the options, as you can see, you have to just apply your mind that when after the judgment is pronounced, can the charge be changed, can be altered? Copy of judgment is given to the parties. Yes, the answer is very easy, that when the judgment is pronounced, any time before that charge can be altered. Till the last mode you can alter it. But once the copy is given to the parties, of course that cannot be done. When the judgment is pronounced, that time also it cannot be done. But before that, any time it can be done. Section 216 of CrPC deals with when the court may alter a charge. Question number 91. Under CPC, the court shall have a jurisdiction to try all the suits of a civil nature, excepting suits of which their cognizance is. Now, this is also another important provision from CPC. Very important area, and if you know that section, you can easily answer this. And yes, which section is that? Reading the options, you can easily the section should click into your mind, and the option is D, either expressly or impliedly barred. And this has been directly picked from section 9 of CPC, that the courts can try all the civil suits unless barred. Expressly or impliedly civil nature suits, their cognizance can be taken by civil courts. What is an oral evidence? Direct evidence, statements made before the court of law, depositions made before the court after police has recorded the statement, hearsay evidence, none of the above. Oral evidence is actually what kind of an evidence? This questions also, some people get confused between primary, secondary evidence, oral evidence, what is direct evidence, what is hearsay evidence. तो ये सारे concepts आपके clear रखो. इनमें से कभी कोई question अगर आता है तो statements that are made before the court are actually oral evidences. Evidence means and includes all the statements which the court permits or requires to be made before it, and these statements are called as oral evidence. Very basic question which has been picked here from Evidence Act, but कभी कभी हम confuse हो जाते हैं. Documents तो included in electronic records, they are going to be documentary evidence, but oral evidence whichever is made through statements that are made before the court. Depositions जो आप बनाते हो कोर्ट के सामने, पुलिस हैज रिकॉर्डेड द स्टेटमेंट, उसके बाद ही अगर वो होगी तो दैट ऑप्शन विल बी रॉन्ग ऑन दैट matter, because this is providing that only after the police has recorded the statement जो depositions दी जाती है, that is oral evidence. It is not like that. Any statement that is made before the court is a part of oral evidence. Now going to Conciliation Act. Conciliation involves communication between the parties and the conciliator, which has to be kept confidential, has to be cultured, needs unbiased approach, needs to be restricted at times, none of the above. Now ये स्टेटमेंट पढ़ के आपको लॉजिक अप्लाई करना होगा कि कौन सा स्टेटमेंट सबसे ज़्यादा एप्ट लग रहा है आपको यहाँ पे, एंड द आंसर इज ए, दैट कॉन्फिडेंशियलिटी का प्रोविजन है हमारे आर्बिट्रेशन एंड कंसिलिएशन एक्ट के अंदर. सेक्शन 75 डायरेक्टली प्रोवाइड करता है दैट ये जो कम्युनिकेशन हो रहा है पार्टीज और कंसिलिएटर के बीच में वो कॉन्फिडेंशियल रखना चाहिए. इट इज़ अ मैंडेट. विच ऑफ द फॉलोइंग इज नॉट अ क्वालिफिकेशन ऑफ एन आर्बिट्रेटर? An arbitrator shall be a person of general reputation of fairness, integrity, and capability of applying objectivity in settlement of disputes. He must be impartial. He should acknowledge potential conflicts only. A and B, A, B, and C. Now what they have asked here, be careful with the word not. Majority times हम क्या करते हैं, हम जल्दी में नॉट स्किप कर देते हैं, ऑप्शंस देख के कंफ्यूज हो जाते हैं और गलत मार्क कर देते हैं आंसर. दैट शुड नॉट हैपन. विच इज नॉट अ क्वालिफिकेशन ऑफ एन आर्बिट्रेटर, वो पूछा गया है यहाँ पे, एंड द आंसर इज वेरी इजी. आंसर इज डी, दैट इज ए एंड बी. A and B both is not a qualification of an arbitrator. How? Arbitrator must be impartial? No, arbitrator must be which of the following is not a qualification of an arbitrator? An arbitrator shall be a person of general reputation of fairness, integrity, and capability of applying objectivity in the settlement of disputes. He should acknowledge potential conflicts only. This is the option actually that has been marked over here, that has to be C actually, because rest, as the word not is given over here, so the correct option has to be C, that he should acknowledge potential conflicts only. It is not like that. This is something which is what is opposite. Rest of the things are correct. He should be impartial, he should be having general reputation, fairness, integrity. These options are correct. Correct option will be C, that is he should acknowledge potential conflicts only. ऐसा कुछ भी नहीं होना चाहिए. To the contrary, potential conflicts shall be avoided by an arbitrator. conflicts को बढ़ने नहीं देना है एक arbitrator को. He should give suggestions. So these need to be avoided, and that's the option that is providing for potential conflicts. That is the correct option, because that is not expected from an arbitrator. An oral arbitration agreement is deemed to be a Recognized agreement at the discretion of the arbitrator is not recognized as an arbitration agreement, may be recognized depending upon the facts and circumstances of the case, at the consent of the head of the arbitral tribunal only in exceptional circumstances, or at the implied consent of parties to the arbitration proceedings. So an oral arbitration agreement is deemed to be a recognized agreement at the discretion of the arbitrator, is not recognized as an arbitration agreement. इनमें से कौन सा ऑप्शन सबसे ज़्यादा सूटेबल है ओरल आर्बिट्रेशन अग्रीमेंट के लिए? आर्बिट्रेशन अग्रीमेंट के लिए सेक्शन 7 सबसे ज़्यादा इंपॉर्टेंट है एंड द करेक्ट आंसर इज बी, बिकॉज ओरल आर्बिट्रेशन अग्रीमेंट इज नॉट a valid form of agreement because necessarily mandatory है कि arbitration agreement writing में होना चाहिए, and the answer is very easy. International commercial arbitration is defined under, yes, international commercial arbitration is defined under which part of arbitration? You have not been asked the section, but you have been asked the part of the act. ऐसे भी कभी हो सकता है, so be clear with the sections and the parts, which part is dealing with which provision. That also, if you know, you can easily answer this. Part 1 provides for international commercial arbitration. We get confused that whether this commercial arbitration is coming under part 1 or it is coming under part 2, as we get confused that domestic awards are covered under part 1, but don't get confused. Section 2 clause F directly provides for international commercial arbitration and its definition. 97. Transaction of transfer of ownership in the property for a price partly paid and price partly promised is very easy and expectable question from the Transfer of Property Act comes here. Yes, which is the answer? Ownership is getting transferred, sale. इससे हमें समझ में आ जाता है कि यहाँ पे sale expect किया गया है. 54 of TP Act, read it, very important section. A contract for sale does not by itself create charge in the property, does not by itself create interest in the property. Both A and B are correct. Contract of for sale, okay, contract for sale and contract of sale are also two different terms. Be aware of such kind of differences. Creates transfer of interest in the property, creates transfer of interest partially. And the answer that is correct is C, both A and B. And does not by itself create any charge or interest in the property. This is defined under section 54 only. You can see the last point defines contract for sale, which directly provides that it does not by itself create any interest or charge in the property. Last two questions for our discussion. Mortgages, transfer of interest in immovable property for securing payment of money for performance of pecuniary engagement, A and B taken together, A, B or C. Now also be aware of such kind of options which are providing for or and, okay. कई बार ऐसा हो सकता है यहाँ पे आपको A and B और C दिया है और यहाँ पे आपको A and B and C दिया है. इनके बीच का डिफरेंस आपको समझना ज़रूरी है. Everything has a different meaning. And or means different. And the answer is E, A and B or C. The answer is mortgage. It is provided under mortgage definition section 58, which provides for the descriptive definition of mortgage, also the mortgager, mortgagee and all. Last question for our discussion today. Suit for foreclosure and sale can be filed by whom? Mortgager, mortgagee, creditors of the mortgager, surety of the mortgager, none of the above. Very easy if you can just know the trick and the basic simple logic that suit for foreclosure and sale can be filed only by the mortgagee and nobody relating to the mortgager, or the mortgager himself cannot file it, as this is something which is a right of the mortgagee. Answer, section 67, right to foreclosure or sale is a right that is available with the mortgagee exclusively after the mortgage money has become due, and redemption similarly is for mortgager, and right to foreclose or sale is for mortgagee. So a suit for that purpose will also be filed by the mortgagee only. So these were all set of 100 questions that we had to discuss for examination point of view. I hope this exercise was very fruitful for all of you. सारे videos को देखिए अगर आपने पहले के videos भी miss किए हैं. Also we have Sebi Grade A Legal Stream online course available at ixamBee. You can find all these features like short videos, practice questions, full length practice tests, doubt clarifying classes at ixamBee. You can also find mock tests at ixamBee that are exclusively available at www.ixamBee.com, and all of these are available for free. We have expert faculty working for legal side. आपके जो भी queries है, questions हैं, आप ये वीडियो के comment section में भी लिख सकते हैं. You can reach us anytime. Contact us for any queries and requests for videos in the comment section also. And don't forget to subscribe to our YouTube channel as we make government exams preparation over here. Thank you so much everybody for joining for all these question series. All the very best for your examination. Thank you.